The notice was taped across my front door in bright red. Unsafe structure, entry prohibited. Not a letter. Not a warning. A full-on condemnation notice on a house I owned. My phone was already buzzing before I even pulled into the driveway. 3 missed calls from neighbors. 2 emails from the HOA. And 1 voicemail that just said, "You need to come here. They're about to board it up." When I got there, a contractor truck was parked in front of the garage, plywood stacked on the lawn, and the HOA president standing on the porch like she'd just claimed new territory. She didn't greet me. She pointed at the paper. "Abandoned homes are a safety hazard. We're securing the property and billing you daily compliance fines." I told her the house wasn't abandoned. I told her I was the legal administrator of the estate. I even showed her the paperwork. She barely looked at it. Instead, she said, "You've had months. The association has authority now. Authority over my house." Then she made the call, right in front of me, requesting a county safety inspection so they could legally force entry. That's when I stepped aside and called the probate office to stop this before it went too far. The clerk asked for the address, then went completely silent. A few seconds later she said, "Wait, why is your HOA touching a property that's under probate court control?" Before I tell you what happened next, if you've ever dealt with an HOA abusing its power, you already know how fast things escalate. Hit like, subscribe, and drop a comment telling me the worst HOA rule you've ever seen, because this situation turned into something even they couldn't control. The house wasn't abandoned. It was my grandmother's. She'd lived there for almost 30 years, same curtains, same wind chimes on the porch, same neighbors who waved every morning when she watered her roses. When she passed, the property didn't immediately become mine. Legally, it entered probate, and the court named me temporary administrator of the estate until everything could be settled. That meant something very specific. I was responsible for maintaining the home, but I wasn't allowed to alter it, sell it, rent it, or let anyone make structural changes until the court finalized ownership. Every decision had to be documented. Every expense recorded. The house wasn't exactly mine yet. It belonged to the estate, and the estate was under court authority. I didn't live there full time. I lived about 40 minutes away and drove over twice a week to check mail, run water through the pipes, keep the yard decent, and make sure nothing deteriorated. The place looked quiet, not neglected, but quiet was enough for the HOA. The neighborhood had always been known for strict rules. Trimmed hedges to identical heights. Approved mailbox colors. Trash cans hidden within 12 hours. And leading all of it was the HOA president, a woman who treated bylaws like federal law. 2 weeks after the funeral, the first letter arrived. Property appears unoccupied. Please maintain active residency standards. I emailed back politely, attaching the probate documentation and my court appointment papers. I explained the situation clearly. The home was in legal transition, and I was maintaining it exactly as required. They responded with a single sentence. The association does not recognize probate as an exception to community standards. A week later, the second letter arrived. This one included fines. The first fine was $50. It almost felt symbolic, like they were testing whether I'd ignore it. I didn't. I emailed again the same day, attached the probate appointment, the death certificate, and even highlighted the section explaining I was legally restricted from making permanent property changes until the court closed the estate. No response. 2 weeks later the second notice came. $100, extended vacancy violation. Apparently, the problem now wasn't the grass height or the mail in the box. The problem was that no one slept there at night. The HOA required active residency presence, something buried deep in their bylaws meant to discourage rentals and abandoned homes. Except the house wasn't abandoned. It was frozen in paperwork. I called the management office. After 15 minutes on hold, the receptionist transferred me to the HOA president herself. Her voice was calm, but the kind of calm people use when they've already decided they're right. I've sent documentation multiple times, I explained. The property is under probate. I'm maintaining it exactly as the court requires. She replied without hesitation. Our responsibility is to the neighborhood's safety and property values. I understand, but legally you can't. We absolutely can enforce community standards. The call ended with her saying the board would monitor the situation. That monitoring started immediately. 3 days later, I arrived to find a landscaping crew mowing the lawn. I never hired them. They handed me a printed work order issued by the HOA. The amount was circled in red ink, $185, charged to owner account. I told them to stop, but they shrugged. They'd been authorized. I emailed again. Attached the same documents. Added a paragraph from the county probate website explaining third-party alterations could legally interfere with estate valuation. No reply. Instead, a letter appeared on the community bulletin board at the neighborhood entrance. Property under observation for neglect. They listed my address. Now neighbors weren't just curious, they were concerned. People slowed their cars passing the driveway. One woman asked if squatters were inside. Another asked if the city was going to demolish it. The fines climbed. $50 weekly, $100 weekly, $500 noncompliance penalty. Then something stranger happened. I came by one evening and the porch lights wouldn't turn on. Neither would the hallway lights. I checked the breaker for fine. The next morning the utility company told me if community safety request had been submitted reporting inactive occupancy risk, prompting a temporary service hold pending verification. The HOA had reported the house as potentially vacant infrastructure. I spent 2 days fixing that. That's when I installed cameras. Nothing fancy, just doorbell and driveway cams so I could prove nobody was trespassing. Within 48 hours they recorded the HOA compliance officer walking the perimeter with a clipboard, twice. On the third visit he tried the side gate. Locked. The next morning I received a certified letter. Notice of safety inspection, forced access scheduled. They claimed the association had reasonable cause to believe the property posed structural risk due to inactivity and could authorize entry if the owner failed to provide interior verification within 48 hours. I read it 3 times. They weren't threatening fines anymore. They were preparing to enter the house. I immediately emailed the HOA board, attached the probate appointment again, and wrote in clear terms. The property is under court jurisdiction. Unauthorized entry constitutes legal interference with an estate asset. No response. Instead, the HOA president emailed back a single line. Abandoned homes become community liabilities. We will proceed accordingly. That was the moment I realized they weren't misunderstanding. They were choosing not to understand. I called my attorney, who told me to warn them one last time in writing. I did, certified mail, signature required. The inspection date remained on the notice. They scheduled it anyway. The inspection was scheduled for 9 a.m. on Tuesday. I got there at 8:20. The street already felt different, quiet in the way neighborhoods get when people are pretending not to watch. Curtains slightly open. Cars parked but engines off. Everyone waiting for something they weren't part of. Then the contractor van turned the corner. Right behind it was the HOA president's SUV. She stepped out holding a folder and a phone, walking straight toward the porch like she'd done it 100 times. The contractor grabbed a ladder and a drill from the van. I met them at the walkway. "You're not going inside," I said. She didn't stop walking. "You were notified. The association authorized a safety verification." I held up the envelope. "And you were notified this property is under probate court control. You don't have legal authority to enter it." The contractor slowed, looking back and forth between us. She didn't even glance at him. "Proceed," she told him. That's when I stepped onto the porch steps and blocked the door. "I'm calling the police." She actually nodded. "Please do." So I did. 10 minutes later a patrol car arrived. The officers listened patiently while she spoke first, confident, organized, pointing to sections of printed bylaws. She described an abandoned structure, safety hazard, and community authority to inspect. Then they asked me. I handed over the probate appointment papers, the court seal still visible on the copy. This house is part of an estate, I explained. I'm the administrator. The court controls access until probate closes. They can't enter or alter anything. The officers looked at each other. One admitted, this is kind of a civil matter. The HOA president crossed her arms. Exactly. Which is why we're proceeding. I felt my stomach drop. For a moment, it looked like they were going to let her do it. The officer called a supervisor. We waited 15 long minutes, long enough for more neighbors to gather discreetly on sidewalks and driveways. When the supervisor arrived, he read both documents carefully. He asked me one question. Is anyone living here right now? No. But I maintain it weekly. He nodded slowly and turned to the HOA president. You can observe exterior condition, but you cannot force entry without a court order. That would be trespassing. For the first time, her composure cracked. This association is responsible for safety compliance. And probate court is responsible for the property, he replied. They left. But she didn't look defeated. She looked annoyed. As she walked back to her SUV, she said, loud enough for everyone to hear. Then we'll let the county condemn it. I didn't know what she meant. I found out 6 days later. I got a call from work, a neighbor. There's a city inspector at the house. I drove straight there. A white county vehicle was parked at the curb, and a man in a reflective vest stood in the driveway writing notes on a tablet. He introduced himself politely and said they'd received a structural safety complaint regarding possible deterioration due to prolonged vacancy. I already knew who filed it. He wasn't hostile, just procedural. He walked around the exterior, took photos, checked the roofline from the street. Because no one was allowed inside, he had to rely on visible indicators. The house looked still. Closed curtains. Empty driveway. Quiet. To him, it probably did look abandoned. By the time I finished explaining probate, he sighed. I understand, he said, but I still have to file a report based on visible conditions and complaint verification. 2 days later, I arrived to a yellow posting on the front window. Unsafe structure, do not occupy. My chest tightened reading it. It wasn't a condemnation yet, but it allowed restricted access and triggered municipal review. Exactly enough pressure to escalate legal action against the property. And the HOA immediately reacted. I received an email that same afternoon. Due to official safety designation, the association will begin protective compliance procedures and billing. They were using the county notice as justification. That night I called a probate attorney. I explained everything, the fines, the inspection attempt, the complaint that led to the posting. He went silent halfway through. Then asked a single question. Did they receive written notice the property is in probate? Yes. Multiple times. Another pause. When he spoke again, his tone had changed completely. Not concerned. Serious. They just interfered with a court-controlled asset. I expected my attorney to tell me how to fight the fines. Instead, he sounded like someone had just handed him a winning case. Listen carefully, he said. This isn't about HOA rules anymore. The moment they acted after receiving probate notice, they crossed into estate interference. I didn't fully understand. They're just filing complaints and issuing fines, I replied. Annoying, but not illegal, right? He exhaled slowly. No. A property in probate isn't treated like normal private ownership. The legal owner is effectively the court until the estate closes. That means third parties, including HOAs, cannot attempt control actions that affect value, title, or possession. I looked at the yellow notice still taped to the window. They reported it unsafe. Exactly, he said. They triggered a government action against an estate asset after being warned. And they attempted entry. And they issued financial penalties. That's not enforcement, that's interference. He asked me to email every document I had ever sent them. Within an hour he called back. I need you to file a petition with probate court first thing tomorrow. We're requesting protective jurisdiction. The next morning I stood in a courthouse hallway holding a stack of printed emails thicker than a book, each one containing the same attachment, the probate appointment papers the HOA kept ignoring. The clerk read the first page and immediately stamped it urgent. By afternoon, the judge scheduled an emergency review hearing. And that's when things got strange. 2 days later the HOA suddenly stopped emailing me. No new fines. No warnings. No threats. Then my attorney received something through discovery request. Internal board emails. Apparently, once they received notice of the hearing, they contacted their lawyer, who demanded communication records. Those records included conversations the board never expected to leave their inboxes. One message from the HOA president read, "If the house stays unresolved, we can lien and possibly acquire it during estate delay." Another board member replied, "Vacant probate homes usually sell cheap after penalties." Then the worst one, "City involvement will speed it up." I stared at the screen. They didn't think the house was dangerous. They thought it was an opportunity. My attorney leaned back in his chair when he finished reading. Well, that explains the sudden urgency. I felt sick. All the fines, inspections, and pressure weren't about safety or appearance. They were trying to financially corner a property that legally couldn't respond quickly because probate takes months. They weren't enforcing rules. They were accelerating a takeover. The emergency hearing arrived faster than I expected. It wasn't a full trial, just a judicial review to determine whether the estate required court protection. But the HOA still sent their attorney. The judge entered, reviewed the petition, then asked a simple question. Did the association receive formal notice the property is part of an active estate? My attorney handed over the emails. The judge flipped page after page, each showing the same attachment sent again and again. Then he read the printed internal messages quietly. The room went completely still. He looked toward the HOA attorney. Are you aware your client attempted enforcement action against a court-controlled asset? The attorney didn't answer immediately. Because there wasn't a safe answer. That's when the judge scheduled a formal evidentiary hearing, not about the fines. About potential misconduct toward an estate. As we left the courtroom, my attorney finally smiled. They didn't just lose authority, he said. They put themselves under judicial scrutiny. For the first time since this started, the HOA wasn't in control anymore. The court was. And courts don't like it when someone tries to outmaneuver them. The full hearing was set 3 weeks later. By then the entire neighborhood knew something serious was happening. The HOA had gone quiet, no newsletters, no violation notices, no board reminders taped to mailboxes. Even the president stopped walking her usual inspection laps every evening. But the court hadn't gone quiet. My attorney spent those weeks organizing timelines, every letter, every fine, every inspection attempt, and every email the board had written when they thought no one outside the association would ever read them. The morning of the hearing, the courtroom was fuller than I expected. A couple of neighbors sat in the back. 2 board members were present. And the HOA president, the same confident posture, but this time without the certainty. The judge entered, and the atmosphere changed instantly. This wasn't about grass height anymore. The HOA attorney spoke first. He framed it as a misunderstanding, a board acting in good faith to protect community safety after observing a prolonged vacancy. He emphasized concern, responsibility, and interpretation of bylaws. Then my attorney stood. He didn't argue immediately. He handed the judge a single binder. Inside was a chronological record. First, the probate appointment notice I sent the HOA. Second, the follow-up email. Third, the certified letter warning them entry would be illegal. Then came the fines issued after acknowledgement. Then the scheduled forced inspection. Then the complaint to the county inspector. Then the internal emails. The judge read silently for several minutes. No one moved. Finally, he looked up. "Counsel," he said to the HOA attorney, "at what point did your client believe they had authority superior to probate court jurisdiction?" The attorney hesitated. "They believed the property posed a risk." The judge interrupted. "I did not ask what they believed about the property. I asked when they believed they could override the court." Silence. My attorney then played the final piece, a printed message enlarged on a board easel for the record. "City involvement will speed it up." The judge's expression hardened. He turned to the HOA president directly. "Did you understand the property was under estate administration when you initiated enforcement?" She shifted in her seat. "We were trying to maintain neighborhood standards." "That was not the question." Another pause. "Yes." The word barely left her mouth. The judge leaned back, folded his hands, and spoke slowly so the court reporter could record every syllable. "The association was notified repeatedly that the property was a court-controlled asset. Despite this, the board imposed financial penalties, attempted unauthorized entry, and triggered municipal enforcement actions with foreseeable impact to estate value." He turned a page in the file. "The internal communications further demonstrate intent to leverage those actions to obtain lien position." The courtroom stayed completely silent. Then the ruling came. Therefore, the court finds the association exceeded its authority and interfered with the administration of an estate. He began listing orders. All HOA fines void. All imposed service charges reversed. County notice to be formally withdrawn upon court clarification. Legal fees to be paid by the association. Then he paused before the final line. "Because the board acted after confirmed knowledge of jurisdiction, liability extends beyond corporate protection. Personal accountability applies to the initiating officer." The HOA president's face lost all color. The judge looked directly at her. "You were informed. You continued anyway." He signed the order. The sound of the pen felt louder than anything said that day. The hearing ended less than 10 minutes later. But the outcome didn't end in the courtroom. As we walked out, neighbors who'd quietly attended stepped aside to let me pass. Not awkwardly, respectfully. Behind me, the HOA board remained seated, speaking urgently with their attorney. For the first time since this started, they weren't issuing instructions. They were receiving them. Within a week, the yellow notice disappeared from the window. The county inspector returned, this time with a court clarification letter, and officially cleared the property. No violations. No hazard designation. Just a house waiting for paperwork to finish, exactly what it had been the entire time. The HOA stopped contacting me completely. A month later, a letter arrived, not from the president, but from the association's legal office. It confirmed all fines were erased, my legal costs were reimbursed, and future communication regarding the property would go through counsel only. 2 board members quietly resigned soon after. By the time probate closed, the neighborhood felt different. Neighbors who once watched from a distance now waved when I pulled into the driveway. One even apologized for believing the rumors. I eventually sold the house, properly, legally, and at full value, something that might not have happened if the pressure campaign had worked. In the end, the HOA thought they were dealing with an empty property. They weren't. They were dealing with a house protected by the one authority they couldn't overrule, the court.